This is part 10. What happens if the Texas non-compete is unenforceable as written? In that situation, there's good news and bad news for both the employer and the employee. Let's start with the good news for the employer. The good news is that you can still get reformation of the non-compete from the court. Reformation is just a fancy word that means the judge rewriting the contract to the extent needed to make it reasonable. Texas is a very pro-reformation state. The Texas non-compete statute says that a Texas court shall reform the non-compete to the extent needed to make it reasonable, and the Texas courts interpret that to mean that reformation is mandatory. The bad news for the employer is that if the non-compete is unreasonably broad, you can't get damages for a breach of the non-compete that occurs before reformation. And that's a big advantage for the employee. On the other hand, employees, you're not home free just because the non-compete is unenforceable as written. In addition to reformation, the employer can still potentially get a temporary injunction to enforce the non-compete to a reasonable extent. So you may still have to go to a temporary injunction hearing. If you do, you need to prepare your witnesses, and I'll talk about that in part 11.